Hello everyone and welcome back. In this video I'm going to talk to you about Baker acting your loved one. Now in the past I've been pretty adamant that you do not want to Baker act your loved one. Why? Well, because it's a statute that allows the state of Florida to take custody of your loved one, and once they do, your rights to make decisions for them are effectively terminated. Their rights to make decisions for themselves are effectively terminated, and somebody who gets Baker acted can, in an extreme situation, end up in a state mental health facility for up to 6 months, which can get extended. They can also forcibly medicate you. So I frankly have not been a big fan of it, because I do believe the state doesn't do a great job of taking care of people. And if you are a family who has a loved one in crisis, then you, the family, the person that loves this person, should be the one making the decisions for them, not the state. But just recently I actually did a piece for the local CBS network here, where we had actually had somebody who'd been Baker acted in the past, and for whatever reason he was allowed to leave. And this happened 3 times until finally he attacked a police officer with a knife and was unfortunately he was shot and killed. And the question is sort of the issue that we were talking about on the network was, how did this happen? How did somebody like this happen? How did somebody who had been Baker acted 3 times not get the treatment, not get the services they needed? Now, the Baker Act, as a general rule, is not a treatment statute. It's not designed to treat anything, but it is designed when someone is in immediate crisis. Now, if you are a family who does not have resources to either file for Marchment Act if there's drug use, file for guardianship if there's mental illness, then I think the only option that you potentially have is to file for a Baker Act. Now, we can help you with that. We can certainly petition the court for some type of emergency order, which would authorize the police to come down and pick your loved one up and take them to the nearest receiving facility. But understand this, and I want to be really clear about this if you decide this is the route you want to go, that if it's granted, if the court grants such an order, your loved one can be held anywhere between 0 and 72 hours, and potentially much longer. As I previously mentioned, up to 6 months, they can get sent to a state facility. But once we do that, the right to make decisions for them, it's over. You are not going to be able to do anything. The state is taking over. You are basically asking for a court order to give your loved one over to the state. Now, if you don't have the resources, financial resources for treatment, or you don't have health insurance, then perhaps this is the last port of call. There's nothing else you can do. I would rather you did this than did nothing. So I'm happy to do it. I just want everybody to understand that if we do it and it's granted, that the state takes over. And that's it. That's my thought. I think that the Marchment Act and guardianship and a combination thereof is a better option. But I even said this to the network. I said there's a 2-tier system here in Florida. One for people that have resources and one for people that don't. And if you don't have resources, you can be SOL. And I think it's shameful, quite frankly, but that's perhaps a topic for another video. The bottom line here is that if you have no resources to get your loved one to treatment, they are really in crisis because of some type of mental health issue, and it has to be mental health. Substance use is specifically excluded by the Baker Act. So if it's just drugs, the Baker Act is not the statute. But if they are in need of immediate services and you want help, yeah, we're happy to file a Baker Act for you. So with that said, I appreciate you tuning in, and I'll see you in the next video. Bye-bye.